Misrepresentation in contracts can have serious legal and financial consequences. Whether you're entering into a business agreement or making a major purchase, understanding how to prove misrepresentation is crucial for protecting your interests. Misrepresentation occurs when false statements impact contract agreements. It falls under the broader category of fraud, but has some key distinctions. There are three main types of misrepresentation: innocent, negligent, and fraudulent. Innocent misrepresentation happens when a false statement is made without knowledge of its inaccuracy. Negligent misrepresentation occurs when a party fails to verify the truth of their statements. Fraudulent misrepresentation, the most severe form, involves intentional deception. To prove misrepresentation in court, several key elements must be established. First, there must be evidence of a false representation of a material fact. This means the misrepresented information was significant enough to influence the decision to enter into the contract. Second, the plaintiff must demonstrate that they relied on this false statement when agreeing to the contract. This reliance must be reasonable. If the plaintiff had an opportunity to verify the facts but failed to do so, the claim may be weakened. Third, there must be a direct link between the misrepresentation and the plaintiff's decision to enter the contract. Finally, the plaintiff must show they suffered damages as a result of the misrepresentation. The legal implications of misrepresentation vary depending on its type and severity. In cases of innocent misrepresentation, the usual remedy is contract rescission, which essentially undoes the agreement. For negligent or fraudulent misrepresentation, the injured party may sue for damages. In particularly egregious cases of fraudulent misrepresentation, punitive damages may be awarded to punish the wrongdoer and deter similar conduct in the future. Some cases may even lead to criminal liability if they involve extensive fraud. Let's consider an example to illustrate these concepts. Imagine someone is purchasing a used car. The seller assures the buyer that the brakes are in excellent condition. The buyer purchases the car but soon gets into an accident due to faulty brakes. Upon inspection, it's revealed that the brakes were severely worn. In this scenario, if the buyer can prove that the seller knew about the poor condition of the brakes but deliberately misrepresented them, this could constitute fraudulent misrepresentation. The buyer might seek damages for injuries, vehicle repairs, and potentially punitive damages. However, if the seller genuinely believed the brakes were fine but failed to have them properly inspected, this might be considered negligent misrepresentation. The buyer could still seek damages, but punitive measures would be less likely. It's important to note that defendants have several potential defenses against misrepresentation claims. These include arguing that the misrepresentation wasn't about a material fact, that the plaintiff didn't actually rely on the false statement, or that the plaintiff should have conducted their own due diligence. Given the complexity of misrepresentation claims, seeking legal counsel is often crucial. An experienced attorney can help gather evidence, build a strong case, and navigate the intricacies of contract law. Understanding misrepresentation and how to prove it is essential for anyone entering into contractual agreements. By being aware of the types of misrepresentation, the elements required to prove it, and the potential legal remedies, you can better protect yourself in your business and personal transactions.